Welcome to today's webinar, ACA, EEOC, HIPAA, and GINA, What's New in Wellness for 2016. I'm Jenna Westenberg with Health Check 360. We have a great presentation for you today, but before we get started, I'd like to take care of a few housekeeping items. We will have some time for questions at the end of the presentation. If you do have any questions, please type them into the question box in the lower portion of your control panel. We will also be posting a recording of this webinar online, so if you'd like to replay this at a later date, it will be available. Also, if anyone would like a copy of the presentation, please send an email to me or type your request in the question box. Today we have Health Check 360 Vice President Michael Kelly and Vice President Adam Jensen with us to talk about the regulatory environment surrounding wellness. Now I'll turn the presentation over to Michael and Adam.
Great. Thank you, Jenna. You know, this is a tough subject because there's really not a lot of clarity as we look at the regulatory environment and wellness, which is unfortunate because I felt like we had a lot of clarity with HIPAA's initial non-discriminatory recommendations, and then that being really well codified by healthcare reform. And so what's really kind of thrown a wrench into this is the fact that the EEOC has largely taken their own stance on wellness, and now they're trying to rectify what was passed by Congress and legislated in healthcare reform and their own kind of culture and belief structure. And so we really appreciate you for joining a rather dry, but as we can see from the attendance, you know, always a very, very valued and well-attended topic. As usual, Health Check 360 really seeks to provide accurate and helpful information, but this is not intended as legal advice, and you should always work with your primary legal counsel on all matters regarding either your benefit wellness consulting or the management of your internal company wellness program or employee benefit plan. You know, for an agenda point of view, this was kind of a tough item to put together because there's so many moving pieces and there's so many sources that you have to kind of aggregate into one piece. So what I thought was I would do a quick background on the different legislation and regulatory bodies that have gotten involved in this process. And then obviously we want to look at recent events, and that is the lawsuits that the EEOC brought at the end of 2014 and many of the recent developments in those suits at the end of 2015. The real meat of this is what does this mean for our actual wellness and employee benefit plans, because right now we have one set of rules that we know we need to abide by, which is the HIPAA and healthcare reform rules. But we also have a set of recommendations that the EEOC says it's going to look to codify in the near future. And so I'm going to compare what the current rules look like compared to the proposed rules and the proposed GINA rules, all provided by the EEOC. And then a quick conversation about what might be next, and hopefully some answers to your questions. And the reason I say hopefully is because there's just such a great deal of information that remains to be known. So let's dive in. We're going to go pretty fast because there's a lot to consider. And as I said, you know, how do we get into the mess that we're in today? And I call it a mess not because I think that it creates an environment where wellness programs can't be successful. Actually, I believe that the current status quo with the ACA reforms as the current governing law, I think wellness programs can be wildly successful. The mess is that we don't have clarity on what rules we're supposed to be following. So here's the players. I also call this my cheat sheet. Health and Human Services, Treasury, and the IRA are responsible for HIPAA and the Affordable Care Act. The Department of Labor and the Equal Employment Opportunity Commission are responsible for the American with Disabilities Act and the Genetic Information Non-Discrimination Act. So essentially we have 5 separate regulatory bodies, actually probably more, with a hand in this. But as you'll see in the next slide, that the DOL and the EEOC essentially have their own opinions compared to the operating environment established by HIPAA. So as we look at the timeline, these are some of the key events that we really looked at that brought us to today. the HIPAA non-discrimination requirements and wellness program rules were effective way back in 2007, and they were very proactive. They established the difference between participatory and outcome-based wellness programs, and they established the first version of the 5 rules that we're very familiar with for outcome-based programs. Now those rules are obviously applicable to all health contingent programs. When I say we're all kind of familiar, it's the idea that you must give individuals an opportunity to qualify for the reward at least once per year. At the time, rewards for outcome-based wellness were capped at 20% of the total cost of coverage. The program must be reasonably designed. It must be available to all similarly situated employees by providing a reasonable alternative standard, and you must provide adequate notice of that reasonable alternative standard. And frankly, there was no significant abuse or issues in the marketplace for these rules, but you'll see that the EEOC starts its own trek starting in 2009 with the first of 3 informal letters. And informal letters is a really interesting concept, because essentially they were issuing position statements that conflicted with the only stated law, but these statements had no legal bearing, so they just proved to confuse or frankly scare some people. And then healthcare reform comes along, and we essentially get 136 pages of 6-point font codifying the existing HIPAA wellness rules, with significant emphasis on the reasonable alternative process and the incentive structure increasing from 20% to 30 and potentially 50% for nicotine-based programs. But once again, the EEOC decides to be contrarian. At the end of 2014, they filed 3 lawsuits against employers, which shocked everyone because this was before they published their own guidelines, which they said they were going to do. Obviously, this is kind of inconceivable to most rational people, but they moved forward anyway. And so after they bring 3 lawsuits, 5 months later, they actually propose their guidance on bringing the ACA and the EEOC together, which is interesting because their position statements on bringing them together actually conflict in a lot of places, and that's what we're going to spend most of our time talking about today. And in October of the following year, they attempt to balance the wellness rules in GINA, only succeeding in, again, not bringing things together, but making things more complicated. So the most recent updates have largely been positive from an employer point of view, because the EEOC loses 2 of the 3 pending cases on wellness, and a lot more to come on that in a little bit more detail. I'm going to go really quick through this because essentially the timeline covers these components. But HIPAA clarified their non-discrimination rules back in 2006 and have made those effective in 2007. These rules were further codified in the Affordable Care Act and made effective in the beginning of 2014. What I include here is that the intent of the regulators involved here is much more important. You know, essentially the reason healthcare reform looked to provide more clarity is that they largely believed wellness programs to be very beneficial and that they were very important to the long-term controlling of costs in overall health and our health system, as long as individuals were not being discriminated against or that they were a subterfuge for penalizing the unhealthy. So the frustrating part is that essentially the intent of the regulators under HIPAA and ADA should have been the same intent as the EEOC, but I think the difference is they looked at it from the point of view of the employers and health plans were bought into essentially being effective in trying to change health, and they also made the rules flexible enough that employers and health plans could do so in a way that was effective but not discriminatory. You have to remember and remind ourselves that the EEOC's entire job is to prosecute companies for unfairly treating their employees under the Americans with Disabilities Act. So they're coming at wellness programs completely differently than kind of, I think, the good intentions of the other regulatory bodies. Their view of wellness is very skeptical, not positive. Their view of employers is very skeptical, and not that they would actually want to do what's best for their employees. So I think the intent is very important there. And although we can do an entire presentation on the nuance of these rules, and we're happy to help people with their questions regarding, the HIPAA ACA rules. Essentially, it all comes down to these 5 components, which is nothing more than an evolution of the rules established in 2007. So these are the HIPAA requirements for health contingent wellness programs, and one of the things ACA did is it defined almost all wellness programming as health contingent. And we'll see a comparison. I did lay these out compared to the EEOC and GINA in each of these buckets, so we'll have a lot more detail to review and discuss. But essentially, as I noted before, the change here in the rules from ACA was from 20% to 30% and as high as 50% in terms of rewards. So there's where you can see that there was a higher level of trust in the marketplace, but obviously they spent a lot of time making sure that these bigger incentives were applied fairly. The other thing that they spent a lot of time on is really defining the reasonable alternative standard. Wellness providers and health plans have to give a lot of thought to making sure that the full reward is available to everyone. But what is nice is they gave the flexibility to make sure that we're giving the full reward to those employees and participants who deserve it or who have earned it in terms of managing their health. And there's some notice requirements in terms of the availability of those reasonable alternatives. And we're going to regroup on that because I actually think notice is one of the biggest areas where the EEOC is expanding the requirements. So we covered HIPAA, and which is from Treasury, the IRS, and Health and Human Services. Now we get to the impact of the Americans with Disabilities Act.
Hey,
and
Michael?
Essentially, yeah, Adam, go ahead.
Well, I'm just going to back up and zoom out just for a sec, just to give folks some context. And you really have one commission within DOL that is off the page with the rest of the government, because when you look at the HIPAA wellness rules, the 2013 final wellness rules were passed by what are referred to as the departments, and that actually includes DOL as an overall agency, IRS, Treasury, and Health and Human Services. And then those the rules made by those 3 departments were taken and frankly improved upon by Congress. And at last I checked, Congress is the 800-pound gorilla. What are you looking at who's got more smoke, EEOC or Congress? So you've really got one small bureau within DOL fighting the mothership and fighting the rest of the DC establishment. I mean, they're not working and playing well with others. Frankly, the rules, as you pointed out, the rules, they weren't broken, and the EEOC somehow felt they had to fix them.
Yeah, that's great context, and I've kind of lumped DOL and the EEOC throughout this, and it is the EEOC that's driving the contradictions that we're going to discuss from here on out. So, a lot of people have asked me why does the American Disabilities Act impact wellness so much, and it's essentially only because of one clause, and it's the clause that generally prohibits employers from requiring employees to take medical examinations. And because biometric screenings are such a significant aspect of especially effective wellness programming, the EEOC has used that as their entryway into this space. But what's been really positive and kind of really interesting is that wellness programs that are designed with their employee benefit plans in mind typically fall within the ADA safe harbor for bona fide benefit plans which do not comply with the requirements regarding medical examinations for employees. And so the big case here that really kind of brought this to light is Seth versus Broward County. And this exception was essentially tested in 2012 in this case. The court and 2 additional appeals courts ruled that because the wellness program was part of a bona fide benefit plan, the issue was not whether something was voluntary or not, which is the big EEOC contention in later cases, by the way. It was that because it's a bona fide benefit plan, the incentivized biometric screening was legal and that the ADA screening provision was not applicable. And by the way, on this next slide here, note one thing especially. The CEF case was not brought by the EEOC. It was brought by an employee against the county. But the court found that the wellness program was based on underwriting, classifying, or administering risk, which is the qualification for the bona fide benefit plan. And, you know, targeting and identifying risk is the target of most wellness programs that include biometric screening. So smartly, the court commented that the aggregate results helped the county better to administer future benefits, and that the wellness program was not a subterfuge. And the court even added that largely the program was generally well liked. And so this was the first decision way back before any of the EEOC cases that established that not only the ADA, which is what the EEOC uses to stick its nose into the wellness industry, but it's actually the piece that this court used to dismiss the CEF case where the employee was arguing that the highly incentivized wellness program, which shifted costs of his employee benefit plan, was discriminatory and not voluntary. Adam, anything to add to that?
Well, and a couple of quick items, Michael. You hit it right here on the head at the bottom of slide 12. The EEOC was not a party to the CEF case. And I find it both hilarious and disingenuous that their official stance is that they, quote unquote, do not agree with the court's findings in CEF. Pardon me for being contrarian, but it's a little like saying you don't agree with gravity. You know, God bless the EEOC. If they don't agree with the U.S. District Court and the Court of Appeals down in that neck of the woods, that's their right. But as you pointed out, Michael, this case was 2011. You know, a good 2-3 years before the Chicago office of EEOC went rogue and started suing employers here in the upper Midwest. And by the way, the EEOC was forced by Congress to admit that Chicago was running rogue when they were suing employers right and left.
Yeah, and I agree with that, and we note that later. And so, again, that's just really good context for everyone to keep in mind as we discuss these components. Because again, and I won't spend any time here except for some points on the next slide, while all this was going on, the EEOC continued to create kind of their own different history. The EEOC was essentially acting completely independent of all the other events and agencies. And they did this by writing these informal letters that focused on a single theme. And that single theme was the concept of voluntary or voluntariness. Most of these letters also indicated that financial incentives, especially large ones, made a program involuntary, and a theme that would play out in their later lawsuits. And this is important to note because essentially what the EEOC was saying, while the only law we had to govern wellness programs said that you could go up to 20 and then after ACA, 30% of the total cost of coverage, we all knew what the governing components were to financial incentives. The EEOC gave no comment on their opinion of that, and actually they even acknowledged that, which is interesting because later they brought lawsuits completely contrary to the rules that we're playing by. And so again, the primary theme of the EEOC is an issue of voluntary. This becomes very important in the Flambeau decision here that we'll discuss in a few slides. But the commission itself actually said that they haven't taken a position on whether financial incentives for employees to participate in a wellness program determine whether an employee has actually or is given a choice. And later in the Honeywell case, they'll see that if the EEOC thought that the penalties were too high, even though they were compliant with the 30% rule, they filed suit anyway. And then nothing, radio silence. as Adam correctly noted, the USAA made no attempt to reconcile the established rules of healthcare reform and their own interpretation until they decided to start suing people. So we jump to recent events here, and I'm going to bring them all together. You know, in late 2014, the fall and winter of 14, the EEOC in the Chicago office, and again, all of these cases came from the Chicago office, they sued two different companies in Wisconsin and Honeywell in Minneapolis. And the first two were interesting because they were both cases where the wellness programs determined eligibility, where participation in the wellness programs determined eligibility for the health plan. The Honeywell case was only about the size of their incentive program. And although we discussed that the ADA allows for an exemption for voluntary health exams, the EEOC claimed that these exams are not voluntary because Honeywell imposed a penalty on employees who declined to participate. And really the only thing that differentiated Honeywell from other groups was that their penalties or their incentive structure was pretty severe. But I cannot stress enough, it was severe, but it was compliant with the 30% rules. And it's really interesting to see what happens after this. Because the EEOC, 5 months following these cases, decided to actually address their own rules and regulations to address the interaction essentially of Title I of the ACA and financial incentives as a part of wellness programs offered through employer group health plans. And they put these up for comments. There were thousands of comments made. And we'll kind of walk through what these proposals say compared to the rules that we have today. But I can't leave recent events without talking about the Honeywell and Flambeau. So the Honeywell case, the EEOC brought suit against Honeywell International in a Minnesota federal court, requesting a temporary restraining order against the company to prevent them from continuing to operate its wellness program, which required employee participants in the group health plan and their covered spouses to complete biometric screenings and refrain from tobacco use, again, or complete a tobacco cessation program. So they had everything correct. They had a properly designed program. It was designed to promote good health. They offered it every year. The financial incentives or penalties were all within 30% of the total cost of coverage. And they had reasonable alternative designs in place for people who didn't meet their standards. But non-compliance with this program would result in surcharges to the employee's share of their health plan premium. What was absolutely wonderful in this case was that the district court actually denied the EEOC's request for injunctive relief, which means they wouldn't even suspend the program while the lawsuit was going on, because they said that the EEOC had failed, which was the most basic of reasons to bring a lawsuit. They failed to show a threat of irreparable harm, which means that nothing Honeywell was doing couldn't be fixed later or was wrongful in the first place. And the case was later voluntarily dismissed by the EEOC. And so, Adam, what are your thoughts on this case? For me, to put it in English, the EEOC brought a case without providing their own guidelines, which means the court applied the existing law and the CEF application and told the EEOC that they had no case whatsoever.
Well, I totally agree with that. Couple of thoughts here. The other point that I would like to make that really showcases the EEOC's egg on its face in this one is if you're going to court, you're asking for injunctive relief, which means you're asking the court, hey, court, make the other side stop doing this. So they wanted Honeywell to stop operating their wellness plan. You have to show that you are likely to prevail at trial. Basically, you have to convince the court, you know what, make them stop because we'll probably win. There was absolutely no showing, having read the court's findings, that no hope, no snowball's chance, frankly, that the EEOC was going to win a trial on this one. The overarching thing here, in my mind, Michael, which is part of what makes this whole crusade by EEOC so maddening, is that we've got the bona fide benefit plan safe harbor explicitly spelled out in the ADA, 501c. EEOC says, yeah, there's the safe harbor, but we construe it very narrowly. My friend, it's like saying, you know what, gravity only applies on this part of the block. It's just, if they would look at what the court told them 3 years earlier, they might have been spared this. But apparently, they're on a mission from God, and I think they're going to take this one all the way into the ground.
Yeah, I agree. The most recent development was at the very end of the year on December 31st, it's interesting that the Flambeau case against the EEOC, Flambeau moved for summary judgment, arguing that this bona fide benefit plan, safe harbor, exempted its wellness program from the ADA. And again, the district federal court agreed and dismissed the EEOC suit, relying on the district court's opinion in the Seth versus Broward County case, in which the court held that a governmental employer's wellness program established as part of an insured group health plan did not violate the ADA because the program was exempt under the ADA's bona fide plan exemption. And so, as we think about some of the lessons from Flambeau, I've gotten a ton of questions about, does this mean that we can use our wellness program as a gatekeeper into our health plan? And frankly, I still don't think that's the best practice. And we're going to talk about a few reasons why. But the court did actually give a lot of feedback on some lessons, and I think we need to take some things away here from Flambeau. But even though this is the current judgment, I'm going to conclude kind of today's webinar with what I think the EEOC and is going to do with this. And so I don't want you to take these lessons and apply them to either your group or your clients. The first is that wellness program requirement has to be a term of the employer's benefit plan. In this case, the court found that the company's wellness program was clearly a term of the company's benefit plan because employees were required to complete the wellness program before they could enroll in the plan. So essentially, the EEOC was arguing that it doesn't apply for the exemption because it's not part of the bona fide benefit plan. Whereas something that we would consider fairly controversial, which is you have to complete these components to be eligible for the health care plan, the court actually said, no, that made it part of the health plan because that's a very specific requirement. And so that's kind of interesting, and I think that'll be contentious in the future because it's completely contrary to what the EEOC put out in its recommendations. Employees must receive adequate notice of any wellness program requirement. This is just good common sense, and obviously it's already addressed in our existing rules with the reasonable alternative, but also, if your wellness program is determining health plan issues, it needs to be well communicated, and so that's just kind of a good common sense takeaway. The wellness program requirement must be based on underwriting risk, classifying risk, or administering such risk. Again, this is the takeaway that says, in order to fall under the safe harbor, the employer must show that we use this wellness plan to manage our overall employee benefits. So for us, we think it's very important to have your wellness program actually be tied to the available employee benefit plan. We've had people challenge us on that and say they want the exact opposite. They want them to not be tied together. I actually think that the way the courts are making these judgments, that it's best to have your wellness program be part of your overall employee benefit program, and you can still obviously make it available to employees that don't elect your medical coverage. So, but again, it allows you more defense here according to how the courts are ruling on these cases. And then finally, the wellness program must not be mandatory. This court took a really interesting take on this. Although completing the HRA and undertaking the biometric exams were required as a condition of health plan participation, the court found that the program was not mandatory in the sense of being a requirement of employment. And so this court really viewed it differently, and not from a point of view of health plan, but saying it's not a mandatory program. It was a choice essentially to participate and receive health care coverage, but the wellness program, especially again under the ADA, is not impacting employment characteristics. And so it's something that the court said the employee could certainly refuse to participate in the wellness program and still remain employed. And finally, I didn't include it on the slide, but again, the court said that this program is not a subterfuge for discrimination. And so again, meeting both kind of the healthcare reform and also the ADA's requirements for being exempt on a medical examination. So this is the really big case, and I'll have some thoughts at the end about how, again, does this give us free rein to be more aggressive? I wouldn't advise that yet, and we'll have a few more thoughts on that. But before I move forward here, Adam, what are your thoughts on the Flambeau ruling?
Well, a couple of thoughts here, Michael. One, the hot button from the EEOC perspective is the ADA prohibition on requiring employees to take medical exams. So they're not looking at this as a health plan thing or a wellness thing. They've got exams on the brain, as it were. So I mean, there is a explicit ban in the ADA. Can't make people take examinations except under certain circumstances. So that's where the EEOC is coming from. The other takeaway I'd have from this is talking about the mandatory nature. I was pleasantly surprised by how the court looked at this as really not being a mandatory exam from an ADA perspective. Having been in the industry for 30 years, I've seen a lot of biometric wellness programs used in the gatekeeping, eligibility function. From an ACA or healthcare reform perspective, I don't think it's a best practice to make your wellness program a requirement to be on the health plan for the simple reason that under the employer shared responsibility rules, aka play or pay, you must offer coverage to full-time employees and their dependents at least annually, and the argument can be made that not taking the exam, if that rules you out of coverage, therefore you could be said to be not offered coverage, which could put you at risk for that $2,000 plus penalty. So sorry to take the long way around on that, but while the Flambeau court said, yeah, you can use the gatekeeping method, probably not a best practice. I mean, it's legal until EEOC appeals this, but probably not a best practice in my mind.
Yeah, Adam, I agree with that, because I think for most health contingent programs using that, some people might not say that the biometric screening is a completely voluntary program, because if someone had a condition that prevents them from doing it, you have to come up with a reasonable alternative. And so if you're following those rules, you've got a health contingent program on your hands. And that was what really kind of shocked me, because the Flambeau case, the court decided it strictly on an ADA consideration, and it doesn't look like they really applied the healthcare reform considerations, where they would still make me kind of nervous with that type of plan design.
It's still lurking there in the background, and it can bite you if you're not looking at all the things that are in play. To make sure that you're not going to end up biting yourself when you don't mean to.
That's right. That's right. And exactly on that note, as a transition, what we found as we were putting this together was that it's really challenging to actually kind of bucket how all of these different organizations kind of view similar issues. And so that's what we sought to do. And, what's going to be interesting here is that as we poured through hundreds of pages of the Federal Register commentary and articles on this subject, we didn't find any great way to organize this myriad of conflicts between the three laws, essentially. What I mean by that is ACA, the proposed rules from the EEOC, and the proposed rules on GINA and wellness. So what I did was I kind of tried to create this presentation as a reference point for all of our attendees, and we'll be able to provide the deck to you. But what that's done is it's created a bunch of overly detailed and monotonous slides. But you'll have a good reference for later. So I'm sorry for the masses of text, but we're going to touch each of these on kind of a high level, and we can touch anything that we may have missed or a concern that you may have, either in questions, or we're happy to arrange for specific follow-ups on your concerns. But obviously, there's just too much detail to really cover in an hour here. But we're going to do our absolute best, and I'm going to try to bring out the highlights of where we think, again, the HIPAA and the Affordable Care Act, in terms of their application of the ADA laws. And so the first bucket is, what's that, Adam?
Well, I just want to make sort of a blanket disclaimer to folks. If you find this confusing, that means you're paying attention. Michael and I have a hard time following this, and this is what we do for a living. So if this is clear as mud, you're in there with the other 99% of us. This is confusing, and it's a moving target. Absolutely,
and that's right. And mainly it's because even from the very beginning, the covered employees or programs, how HIPAA and ACA differentiates between who this applies to is different from the EEOC with ADA and GINA. So GINA. HIPAA and the ACA differentiates between participatory wellness today and health contingent wellness today, where it's going to be an important consideration throughout that the EEOC gets rid of that consideration. So the 5 rules that currently govern our world today, they're trying to balance their policies with those rules for all wellness programs. It gets rid of the distinction between the two. So this is really important because essentially the EEOC is saying that there's a 30% cap on its rules to all wellness programs, not just the health contingent ones. And so, as we look to rectify their rules and regulations, this seems like something that's pretty small. It's actually a really big deal because it's saying that all wellness programs sponsored by covered employers are prohibited from discriminating, so they treat everyone the same, and they do not differentiate between participatory wellness and health contingent wellness. GINA is a little unique here, and I might have this in the wrong place, but GINA is not applicable to most of the things that we're talking about until we get to some of the incentive design. But essentially, most wellness programs accommodated the GINA requirements when they removed the request for family history. But what the EEOC complicated was the inclusion of spouses. And we're going to clarify that on the incentive components and not the covered employees here. This is a pretty simple component that most of the groups agree on, but again, there's one little nuance. Participatory wellness plans don't have any reasonable design requirement today, right? That's a component of one of the 5 rules that only applies to health contingent wellness plans. The EEOC and GINA, in both their guidance relative to wellness, said that anything that you're asking employees to do must be reasonably designed to promote health and prevent disease. And frankly, I don't think that's going to be an issue for most of the people on this call, because I think everything that they're doing, including participatory wellness plans, would probably meet the overall, and by the way, it's just kind of a good sense, reasonable design to promote good health. But interestingly enough, because ACA differentiates between health contingent and participatory, technically participatory doesn't have to meet any type of kind of common sense, reasonable design requirement. The EEOC actually sought feedback, and when they posed their proposed regulations and comments, they actually asked people for further clarification of what reasonable design is. And our comments back to the EEOC certainly said that this should not be very specific because, again, it's not a problem in the marketplace today, but we certainly wouldn't want to restrict the design of wellness programs from to a regulatory body who in wellness programs. So my concern here is that today they do not have specific guidance on what reasonably designed means, but they asked for it, and that bothers me because I am concerned that in the future they may try to define what's accepted and what's not, and that could potentially stifle innovation, aggressive design, and the flexibility we have today to create new wellness program, new incentive designs, and new specific programming, whether it's technology or activities, to really push the envelope on how to expand the success of wellness initiatives. Frequency of reward, again, just lots of contradictions. Participatory under ACA, there's no requirement. Health contingent plans, we know the 5 rules say you must provide it at least once per year. The ADA did not put any type of frequency reporting, so this is kind of ironic that they did not address frequency in the proposed regs, but they did reiterate that you cannot reward for genetic information. It's kind of strange that they put that in this bucket, but you can reward a spouse for health information. There's more to come on that. But again, the whole point of this exercise from the EEOC point of view was to reconcile the rules governing wellness under HIPAA and ACA and their requirements under the ADA, and they completely ignored one of the 5 main components. And so not helpful at all. Remains to be seen if they'll be adding or if they just assumed that if you have to follow it under ACA that they would meet this consideration. So it was either not a high priority, which is interesting because discrimination is supposed to be their highest priority, and they did not address frequency whatsoever. Voluntary. This is where things get really interesting because HIPAA and ACA do not define or provide a requirement on what voluntary is, because the way they wrote their regulations is for that every participant can receive the full amount of any reward or incentive regardless of any health factor. So essentially they didn't need to define voluntary because they built the reasonable alternative processes, and they defined those in such depth under healthcare reform and made those effective in January 1, 2014, that it was also well laid out. They didn't need to define voluntary. But this is an important consideration because the EEOC's fixation on wellness was whether taking biometric screenings or medical examinations was voluntary or not. And they've at least backed off of where they lost these lawsuits were saying, and I'll get to the incentives. They did concede that you can now provide financial incentives up to 30%. But by the way, they didn't do it consistent. But they did note that participation in programs, employers cannot require employees to participate. You cannot deny health insurance or reduce health benefits for not participating, or you cannot take adverse employment action against an employee on the basis of that decision or the failure to achieve certain health outcomes. So their proposed requirements are very specific in addressing the type of design that both Orion Energy and the Flambeau case was exactly about. So, Adam, what are your thoughts on this? Because again, their theme, as you noted, is all about screenings and whether screenings are considered voluntary or not.
And again, in my mind, Michael, this all tracks back to the ADA fixation on not requiring employees to take medical examinations. Now, with the ADA regs, looking at this, we probably are going to see some relief given the flammable situation, ultimately dependent upon how the appeal, if any, goes forward. We may be stuck with the GINA rules because there is no a bona fide benefit plan exception within GINA. Again, for about as long as I can remember, EEOC has had an unnatural fixation on the voluntary nature of exams, and that tracks back to really just looking at ADA and the prohibition on employee exams without actually tossing in some common sense and taking into consideration the 501c exception, safe harbor.
Yeah, I agree. And to note on the GINA aspects of voluntary really focuses on the collection of family history data, which is largely, again, a non-issue, as most HRAs and wellness programs have removed those questions. So it provides a lot of parameters on, if you are going to include those questions, what you have to do. Again, I think the best practice and what I've seen most wellness vendors in our space do is to remove those components. As much as we would like to have that data, and then I think it's important to be able to talk to people about family history, it's not worth, they've made it administratively too burdensome to really undertake that component under a wellness initiative.
I would agree.
So
again, it wasn't broken, but they decided it needed fixing anyway. Yeah.
And considering the next one is the other massive component here as we're moving through and looking at this is the limit on incentives. Again, most people found that the system under HIPAA and healthcare reform was not broken, and it was very clear. Again, it's divided into two buckets, which complicates things a little bit. In that participatory wellness plan, there's no limit on incentives, but it's our personal view that there's very few wellness programs that meet the definition of purely participatory. Health contingent programs, which is the majority of wellness programs that involve biometric screening and other programs that involve some type of activity, had a cap that cannot exceed 30% of employee-only coverage, or up to 50% if the program is designed to prevent tobacco use. And if the reward allows spouses or dependents to participate, those same percentages would be applied to the total cost of family coverage, but only if dependents and family are allowed to participate. So kind of very clear, right? If it's just the employees allowed to participate, it's 30% to 50% of the employee-only coverage. And if families or spouses are allowed to participate, you can go up to 30 or 50% of the family coverage of the tiers that are being allowed to participate in the wellness incentives. The EEOC here really complicates this issue because they made it a much more complicated math problem, and I'll do my best to explain this. For wellness programs that are part of a group health plan, employers may offer limited incentives for employees to participate or to achieve certain health outcomes, and they cannot exceed 30% of the total coverage. The tobacco consideration I will get to on the next slide here. If an employee and a spouse participate in the program, the EEOC complicates it. They say that the employee's portion of the reward would be limited to 30% of the cost of employee-only coverage. The difference between 30% of the applicable coverage and that number could then be used for the spousal incentive. So I understand that probably doesn't make any sense to anybody, so I'm going to give you an example. If the family premium is $14,000, so the example here is if we have employees and spouses available, 30% of that would be $4,200. But in order to figure out the actual parameters under the EEOC, we actually have to do the math of the employee-only premium. So let's say that's $6,000. So 30% of that is $1,800. So a plan could only use $1,800 for a health contingent incentive for the employee, but they could use the balance, $4,200 minus $1,800, which is $2,400 for the spouse. So again, completely backwards. Again, we have a group that doesn't know anything about our industry trying to dictate a different system than one that was already effective. So under their definition and how you have to do the math, you can only incentivize the employee up to the employee-only premium, and then you can use the balance of 30% of the family premium to incentivize the spouse, which is fascinating because their whole concern under GINA was their extent to what they were going to allow employers to incentivize spouses. And the math that they came up with actually created a system that for most plans, you're going to be able to have a higher dollar amount for spousal participation than for employees, which again is just very strange twist considering that the EEOC's concerns were largely in another place.
Michael, don't go confusing things with the facts again.
So that is my fault, yeah.
It is quite telling, though, that if you look at the progression on the HIPAA wellness rules, they have stayed remarkably consistent since 2006. We've got a decade of consistency. It's gone from a little bit conservative to actually being more user-friendly, obviously with the congressional widening up to 50% of the program. And then you've got ADA and GINA under EEOC who doesn't understand wellness but is happy to try to legislate it. So.
Right. You know, and on the GINA side, essentially you cannot incentivize the provision of genetic info. That's pretty straightforward. And then they address essentially if you have spouses involved, again, you can go up with that 30% rule, but the math, you have to work between the GINA proposed rules and the wellness proposed rules from the EEOC to come up with that math. And yet there's one more contradiction that to wellness people doesn't make any sense. So the EEOC actually did say that you can potentially go up to 50%, potentially, again, these are all proposed requirements, for smoking cessation programs. But this goes back so specifically to Adam's main point that is so important to know. EEOC's preoccupations with screenings, they actually are trying to legislate something that's completely contrary to best practice in terms of wellness and medical management. And what I mean by that is that the EEOC is suggesting in their rules and regulations that you can still go up to 50% for a smoking cessation related program or a tobacco related program, but only if that program does not involve a biometric screening or medical examination that tests for tobacco. So here's the absolutely unbelievable contradiction. So wellness programs that are actively seeking to get accurate information, meaning they're testing for nicotine or serum contanine, they're only allowed to incentivize up to 30%. But those programs that rely on self-reported information, which all the research in the world tells us is highly unreliable, and especially if you have a high of 50% incentive involved, where people can simply lie on self-reported information, those programs can incentivize up to 50%. So again, the EEOC's fixation, as Adam said, on trying to avoid screenings is actually potentially legislating not just the opposite of best practices, but something that I can't believe somebody wrote down that said, if you don't do screenings, you can do 30%, but if you do screenings, or excuse me, if you don't do screenings, you can penalize up to 50%, but if you do screenings, you have to keep it at 30. So Adam, any thoughts there?
Lots of thoughts, but none of them that I dare share on an open mic right now. It's pretty clear to me that I'm not getting a Christmas card from the EEOC this year. It just plain doesn't make sense. And Michael, I think I summed it up with you yesterday when I was looking at the material here. This whole approach from EEOC, it reminds me of the ending of that movie Thelma and Louise, when you know they're going over the cliff and there's not a thing you can do about it. This just isn't going to end well, and
right.
And it's unfortunate. I mean, I think we had some really good time-tested regulation from DOL, IRS, and Health and Human Services, plus Congress, before we got this sort of like 88 GINA twist added in, and we'll just have to see how this works out.
Right.
It'll be
right.
interesting.
So as we
I'll get off my soapbox.
As we finish up here, I want to make sure we get through all the data in the hour, and then we will stay and answer questions for as long as it takes to address people's concerns live. And oftentimes we get some really good in this subject matter. So, you know, uniform availability, I won't spend too much time. HIPAA and ACA spends a lot of time on reasonable alternative to make sure that health factors do not prevent the availability of the full reward, which is why we think most of the EEOC guidance is unnecessary. And then obviously they don't address it because of the very next slide. You know, they don't address it because they simply use different terminology. Again, where we use the reasonable alternative in HIPAA and ACA, the ADA calls it reasonable accommodation. So because we break it into participatory and health contingent, and that's determined oftentimes the eligibility of the health plan, the ADA views it as all employees and all eligible, and you must make reasonable accommodations to make sure that employees with a disability have the opportunity to fully participate and earn any full reward. So again, had a system in place that was working. This is largely a terminology issue, but they made sure that they complicated it a little bit also. This last piece is on notice, right? And I'm not going to spend much time on HIPAA ACA because we all essentially know that you have to have a reasonable alternative and you have to communicate it essentially everywhere in your plan documentation that discusses the rewards, or especially if the program impacts the plan design and the cost structure for the employee. We also know you've got to get it, you've got to disclose it when the individual is aware of the standard or the failure to meet a standard. But what I want to note is how the EEOC is actually expanding this. The EEOC is requiring that we must disclose the availability, the EEOC is that we must provide employees with a notice of a lot more things. And that is describing what medical information will be collected. That's going to be a very complicated document. They want to document who will receive it. You know, and this is going to potentially make it administratively burdensome to get the best data into the right hands, right? So if you add a disease management program and you want them to have the biometric data from your wellness program, the EEOC is going to mandate that you have to issue a communication to all employees that a new entity is going to receive their data. Today, all of that is governed by business associate agreements, ERISA, and existing privacy laws. So again, no issue, but I think you're going to see a massive amount of exceptions, questions, and administrative burden because EEOC is saying that we have to disclose and create employee communications on what's being collected, who will receive it, how the information is going to be used, and how it's going to be kept confidential. And I think largely those things are good to be transparent on. Most programs are completely transparent on those questions when asked by an employee. But what I expect to happen here is that this is going to add extensive administration burdens to both employees, employers, and vendors. And obviously, additional administration burden has the potential to increase the cost to the marketplace. And so, again, I think this notice is a much bigger issue than they think, and it's addressing a problem that doesn't exist today. So I'm going to fly through these slides here on the potential impact. You know, again, so many programs today have biometrics involved, and so many programs are linking these things to results and advanced outcomes. And so 88% of large employers, according to Mercer, these EEOC changes are going to impact. As Adam noted, I don't think this is an administration changing their position from healthcare reform. The lawsuits were largely the result of a rogue office, but the EEOC proposed regulations are a result of the national entity at the Equal Employment Commission. And there's been a significant backlash to this, including new legislation proposed in March of 2015 that's Congress is trying to actually legislate the differences between the EEOC and ACA, which we like because it's Congress that came up with the ACA rules that were working in the first place. So that would be a positive development, but again, that's not a high priority of the current political structure, so that I would expect to be pretty slow moving. So my advice to employers today is that they definitely need to be fully compliant with the ACA and the HIPAA regulations. But I think it's important that no doubt the Flambeau decision will be seen as a victory for employers. I think that employers should proceed with caution before making wellness design changes based on a reliance of the applicability of the ADA bona fide benefit safe harbor exception. It's very likely, because of what we see in these proposed regulations, that the EEOC is going to appeal the Flambeau decision. And even if they lose that case, right, they can still administratively legislate law in their new regulations that they have yet to propose. So you can see that they believe very, very strongly on not having mandatory programs of any type, and they specifically wrote in that the completion of a screening can't dictate whether somebody should get a health program or not. So, you know, I think that type of design, as Adam noted, I think there's some conflicts potentially with the existing rule structure, but also, you know, their final rules that will probably be released sometime this year and implemented sometime in 2017 may dictate that you can't do those things. And so our advice is typically stay the course. And I would expect, as they really kind of dial in what they've proposed, I think that the losses in the courts may have them soften some of those positions, but I really expect to see the regulations in proposed form be the largely controlling factors for the final form. Now, most companies, again, don't have incentive structures greater than 30% of the total cost of coverage, so I don't see drastic changes. What I hope to prevent is that we don't see significant administrative burdens that have been built in to try to solve problems that don't exist today. And so I expect to see a lot more from the EEOC in 2016, but I don't ask any of our clients or any of our consulting engagements to change how they're managing programs today until we see what those final regulations are, because they always provide us enough time to make changes to compliant programs. And I think that if you're compliant with the healthcare reform recommendations and law today, that any changes you'd have to make for the EEOC would be a fairly smooth transition, at least from the point of view of your employees and your overall program design. So I do have concerns about models that are requiring the completion of health risk assessments and biometric screening for health plan eligibility, but I have less concerns about programs that are going up to that 30% of total cost of coverage to highly incentivize participation in those wellness programs, which I think is the best practice as compared to making things mandatory. So, Adam, do you have any closing thoughts before we open it up to questions here?
Michael, I just really totally agree with you. I've got this sneaking suspicion that EEOC may want to pursue its own version of what a reasonable wellness plan is, and have that not be in sync with Congress and the rest of the federal government. If they do that, I would expect some fairly dramatic legal challenges. As I mentioned to you before we went on today, I don't know that we're going to see Congress use the Congressional Review Act as a means of blocking the EEOC rules for political reasons. We currently have a GOP-dominated Congress, and defending what could be interpreted as ACA wellness rules politically would not be expedient for a lot of folks on the GOP side of the aisle. So I wouldn't see Congress suspending the agency rules like you might see with the new FLSA overtime rules later this year. But if EEOC keeps going down the course it's going, I would expect court challenges. Overall, I think employers need to find their comfort spot. You know, you've got from the conservative where, you know what, we're going to make our plans more towards the ADA GINA compliant models by tweaking our incentives and whatnot, or do you feel, you know, more gung-ho to say, hey, this is what the trial court said in Flambeau, and I'm going to make my plan mandatory. You need to find the right angle, the right answer, and right position for your organization. Do
I think with that, we're going to open it up to questions here. And Jenna, I will kick it back to you.
Sure, great. Thanks, guys. I just want to let everyone know before we get into the Q&A portion that we will be sending a follow-up email to all attendees with our contact information. If you have questions that come to mind after the conclusion of this presentation, we understand for a number of you it is lunch hour, you might be jumping off to lunch engagements. So if you do have questions you'd like to address later, we'd be happy to help with that. We do have a number of questions here, and we'll try to get through as many as possible and still get you out of here in a timely manner. So our first question here, can a company raise a participant's health insurance premium if they don't participate in disease management?
Yeah, absolutely. In fact, we have found that plan-related incentives, whether it's deductibles or premiums, linked to medical management like disease management or condition management, whatever terminology you want to use, is a highly effective method of driving higher levels of compliance. In fact, we have some case studies where we've seen compliance of taking medications and seeing the right physicians and doctors being linked to incentivized checking off those activities and being tracked by claims information linked to the plan design jump from 40% compliance to 80% compliance. That is essentially a health contingent activity-only wellness program, and so the existing rules clearly provide for that, and especially since most of the programs with those type of designs are looking for people simply to complete. I don't think that's even considered controversial anymore. I think some of the best outcomes that we've contribution rate, according to the employee benefit plan, is, meaning if somebody doesn't participate or somebody doesn't earn the wellness incentive, that is the number that you have to use for the IRS affordability rules, the 9.5%. How you do that is really up to the company and largely the industry of that company. So, you know, if you have a high earning company and that only applies to a very, very small number of staff members, we've seen companies keep their incentive structures as is, where they potentially, if somebody doesn't earn it, they would be in violation because their potential exposure to penalties is so small, and it's only small if a bunch of things happen, which is somebody not participating or not earning their wellness incentive, then that individual leaving the health plan, then that individual getting a new health plan on the exchange, then they're available to the $2,000 or $3,000 penalty. Many of our clients have actually said they're okay with that because if someone's not eligible for their health incentive, that means that they're going to be a high risk or they're a non-participant, which typically the data suggests makes them a high-risk participant. And the $3,000 is a much lower amount to insure than an $8,000, $10,000, $15,000, or $20,000 individual. That's a challenging design. We like to treat them on a case-by-case basis. Obviously, what I just shared there is a very aggressive approach to it. We've had other clients where they've lowered their incentive amounts to be so small that every employee isn't at risk for that 9.5%. But I don't think that that's the best practice either, because then your financial values aren't high enough to drive the right levels of participation or the right levels of health improvement. To answer your question on, oh, Adam, go ahead.
Well, and Michael, I just want, again, if this, folks, if this is confusing, that means you're paying attention. For ACA affordability, it applies to employee-only contribution on your lowest cost plan. So if you have like your regular plan and then using maybe a safe harbor or high deductible plan, affordability is only going to affect your lowest cost plan. And as Michael pointed out, you want to have your non-incentive rate outside of any nicotine incentive. So basically, your non-incentive rate has to be within that 9.5% using either rate of pay, W-2 Box 1, or federal poverty level as a affordability safe harbor. But again, you only have to be affordable for single coverage on your lowest cost plan.
Right. That's good clarification. Thank you. Oh, on the secondary question, that's something I'd love to connect with that individual offline, because, you know, overall incentive design, you know, 75% of Health Check 360 clients have already transitioned to outcome-based wellness. Outcome-based wellness is showing by far the greatest improvement in the health metrics and consequent cost controls, meaning reduction in trend over time. So we're very, very proud of that. Most of those designs are linking, essentially the incentive structure is the cost of coverage to the health plan to not just whether somebody participates in a program or not, but hits certain health goals over time. And so we'd love to connect with you offline on how we do that fairly and with a minimal administration for the clients.
So our next set of questions is really around the reasonable alternative standard. They are running into two sets of people that believe certain things about reasonable alternative standards. The first feels that reasonable alternative standard plan needs to be designed up front and offered to all employees not earning the top reward. The other group is saying no, a reasonable alternative standard is a customized alternative that can be different for each employee depending on what their issues are.
Right.
So what are our thoughts on that?
Yeah, I don't really have thoughts. I'm very convicted on this because I can send you the federal law language that says you do not have to have a reasonable alternative decided beforehand. I mean, to me, this is not an issue at all. It's in the Federal Register. There's extensive guidance on it, and it's very, very clear that you can create reasonable alternatives as you go. Now, that being said, typically we work with our clients to establish a set of reasonable alternatives that are going to take care of 99% of the most common complaints, issues, or situations that might arise from a wellness program. But that's for administration ease, not and consistency, not because any type of federal law dictates it. So, so to answer your question, we are firmly in the latter camp, where the 2014 final rules on wellness from healthcare reform says that you do not have to have it predetermined.
And Michael, not only that, but you also have patients have the ability to work with their doctors and come up with a reasonable alternative standard as well.
That's right. That's right.
Okay, and a quick follow-up. This will be an easy question. Do employers offering participation-based programming need to offer a reasonable alternative standard?
So that's a great question, and it depends on what the program is. So to me, if the program, to me, almost all wellness programs are health contingent, activity-based, which I would advise people better safe than sorry. The only things that I can think are completely voluntary is someone says, hey, if you want, we'll provide a gym membership discount, and it just applies to all employees equally. For us, you know, even if you just have a voluntary walking program, and if you hit a certain number of steps, you get a $25 prize. If you have an employee that is in a wheelchair or has another issue that prevents them from counting or getting steps, you should have a reasonable alternative for them to be able to get that $25 prize. And so programs that we would historically have thought to be just voluntary, I either did it or not, and if I didn't do it, I don't get the prize. Consequently, the 5 rules don't apply. I think 9 out of 10 times they are typically health contingent, activity-based. They're not health contingent outcome-based, but the 5 HIPAA rules apply in almost all situations. And that's why I actually was really surprised by the Flambeau decision, because I would have personally, as a plan designer, would have not said that you can't be on the health plan, because I would have thought that the 30 to 50% cap would have applied.
Okay, great. That actually answers one of our follow-up questions as well. Is something truly participatory if there's activities to be completed?
Yeah, we don't think so. By the way, that's a contentious question. And, you know, I talked to another counsel that believed that the Flambeau decision was very clear, because, you know, they said that it was truly a participation decision, so the 5 rules didn't apply. My thought for them, and they kind of got stumped, I said, well, what if somebody couldn't do the biometric screening because they're going through chemo for cancer? You would have to provide a reasonable accommodation under ADA language, which is a reasonable alternative under our language. So to me, if that's your consideration, I think you would probably have to figure out a way for them to get that incentive, and at which point you are essentially following the 5 rules. And so for me, that's a better safe than sorry. And that goes back to Adam's level of how people define that. You need to work with your internal company's appetite for risk and your counsel's appetite for risk.
Okay. Here's an interesting question around personal medical that outlines that procedure or any laws.
Well, obviously the laws that dictate that are HIPAA and high tech. Any entity that's combining those data sets or transferring medical records, biometric data, health risk assessment responses is going to be bound by HIPAA privacy rules and the high tech updates of a couple years ago. And so there's a lot of laws governing that. There's nothing specific to the wellness regulations from healthcare reform, GINA, or, GINA High Tech applies to that, but certainly nothing in the latest, in the April EEOC, where they're trying to address the wellness and their own thought process when it comes to employee medical records. I think the law is just very clear on the requirements. That's essentially the HIPAA requirements for sharing protected health information, and that goes to the entities that are sharing between those things are governed by federal law under HIPAA. Adam, anything to add to that?
Well, a point I'd make is that under HIPAA, and this has been really consistent since 2001, individuals can share their own PHI with whomever they wish. For example, I give my doctor a copy of my Health Check 360 screening every November when we do them, and we actually go over it. And that's my choice. And
right.
Then I just depend on my doctor to make sure that the clinic is following all the HIPAA rules. But the general rule under HIPAA is that plans can use information for healthcare operations. They have to take reasonable and appropriate precautions against reasonably anticipated risks.
Absolutely. All right.
Okay, I think that's all the questions that we have for today. If you have any follow-up questions, we will be providing you with our contact information in the follow-up email, along with a link to the recorded webinar if you need to share this with any coworkers, team members, brokers, or clients. So I just wanted to let you know about that. So that concludes our webinar for today. I hope you all enjoyed the presentation. We appreciate you sticking through it with us with this long and detailed topic. In the meantime, keep your eyes open for an invitation to our upcoming webinar, a case study on wellness and workers' compensation. Have a great day.